Rakoff and his new book, Why the Innocent Plead Guilty and the Guilty Go Free. For those of you not familiar with how this virtual format works, although you're not able to, or we're not able to see you, you'll still be able to ask questions if you'd like. To do so, just click on the Q&A icon at the bottom of your screen. The chat function also will be active, and in that column, you'll find a link for purchasing a copy of Judge Rakoff's book. Judge Rakoff has been a federal prosecutor, defense attorney, teacher, and federal judge. He's currently a senior U.S. District Court judge in the Southern District of New York, where he served for 25 years, and he also teaches law at both Columbia University and NYU. When Judge Rakoff declares our legal system is broken, as he does in his compelling book, he's worth listening to. He argues his case through a series of searing essays examining why innocent people plead guilty, why high-level executives aren't prosecuted, why you won't get your day in court, and why the judiciary is curtailing its own constitutionally mandated power. In short, whatever ideals we may have about fairness and equity being served in our courts, the reality Judge Rakoff shows falls far short of that. Publishers Weekly called the book an excoriating and exceptionally knowledgeable analysis of flaws in the U.S. justice system. And the Kirkus Review observed, not every citizen will read this book, but we'd be better off if a good many did. In conversation with the judge this evening will be Troy McKenzie, who like the judge, also teaches law at NYU. Professor McKenzie's scholarly interests include bankruptcy, civil procedure, and the federal courts. And several years ago, he took a leave from the law school to serve for a couple of years as a senior official in the Office of Legal Counsel at the Justice Department. So Judge Rakoff and Professor McKenzie, the screen is yours.
Thank you.
Thank you. Judge, first of all, let me say how much of a pleasure it was to read this book. I was familiar with some of the points, having read your work with interest in the New York Review of Books over the years. But some of the points you make struck me anew, perhaps even harder this time, piecing everything together in one volume. Before we turn to the contents of the book in detail, though, I wanted to ask you a question that's maybe a little bit more personal, hearkening back to something that my old boss, Justice John Paul Stevens, called learning on the job. He was very forthright about the fact that when he first came to the bench, he had a number of views and assumptions that confronting cases over the years forced him to grapple with and forced him to rethink. So could you talk a little bit about what led to your decision to start writing and the decision to write this book? And was this the result of having learned on the job, maybe coming to the bench with some assumptions and suppositions that you saw didn't fit the reality that you had to confront every day?
So that's a great question. And thank you for mentioning that you clerked for Justice Stevens, who is truly one of the great justices, even though he was a Chicago Cubs fan, so we're not all perfect. It was very much what I was seeing in my court, what I was seeing in other courts, that finally got me to feel I had to speak out. I think judges by nature tend to feel that it's awkward for them to speak out on issues, even though the code of conduct of judges actually encourages judges to do so. But every day I was in my court, for example, sentencing young men, usually of color, to inordinate terms required by mandatory sentencing laws that I had no power to change. Every day I was seeing how uh, working class folks who wanted to be in court or who were dragged into court couldn't afford a lawyer and were at a tremendous disadvantage as a result. And then I was also learning a great deal from the work of the Innocence Project and their exonerations of people who had been not only convicted beyond a reasonable doubt, but who had had their convictions affirmed repeatedly by appellate courts, only to learn through the advent of DNA that they were actually innocent. So after a while, all of this got to me, and I felt I needed to speak out, and for better or worse, now I have. So.
Well, why don't we start with your chapters touching directly on the criminal justice system, which are some of the most disturbing. And I think to those who may not have followed some of the developments in criminal law and criminal procedure over the last 10 or 15 years, I think these chapters will be a wake-up call. I wanted to start with your discussion of mass incarceration and what led us to where we are now, which is that the United States locks up a large portion of its population compared to just about every other, certainly every other advanced liberal democracy in the world, and even more than lots of countries that are not advanced liberal democracies. Could you comment a little bit about one aspect of the chapter that really led to a fair amount of head scratching on my part, which is whether or not the current system of criminal punishment, which is harsh, which relies very heavily on plea bargaining, which we can talk about in more detail, and which is attached, certainly at the federal level and also in most of the states, to very long sentences of imprisonment. Does that system make us safer from your perspective that you can detect?
So it's funny because as we Americans always pride ourselves on being the leaders of the free world, but we are also the leaders of the unfree. 25% of all the people in the world who are in jails or prison are in jails or prisons in the United States. There was a time when we would boast, we were number one in the world in car sales or things like that. Now, our shame is that we are by far number one in putting people in prison, both in per capita and in absolute terms. And it's about 2 million plus people every year. That statistic has been constant for at least the last 20 years. And it's a result, as you correctly pointed out, of very harsh laws that were passed in the 1970s, 80s, and 90s when crime rates were going up in this country. And the question then becomes, well, maybe it worked because crime rates came down. There have been a lot of studies of this. It's not an easy thing to study, but there's no study that suggests that the crime rates have come down primarily because of the greater incarceration. There's a big debate as to whether it accounts for as much as 40% of the reduction or as little as 5% of the reduction. All of this is sort of hunches. It's really not something that can be well studied. But there are things we know for sure. We know for sure that 60% of the people we lock up are young men of color between the ages of 18 and 34. We know for sure that in virtually all those cases, it has a ruinous effect on their lives, on their families' lives, on their communities' situations. So it would have to be shown to me that it really was the result of steps that hugely reduced crime to justify such a ruinous result as that.
But a skeptic would say the vast majority of people who are in prison, in the state systems and in the federal system, get there because they plead guilty. They have gone into court, and except in those courts that will allow a defendant to plead guilty but maintain innocence, they have agreed that they have committed criminal acts. So, I mean, why should we really be so concerned? Sure, the laws are harsh, but in some ways, people have voluntarily agreed that they will accept guilt and the punishment that follows from that guilt.
So there are two aspects in answer to your question. The first is that these are human beings who could lead much more productive lives if they were given a chance to do so, rather than being locked up, not just for 6 months, but for 10 years and 20 years and 30 years under these very harsh laws. We are basically saying, you committed a crime, so the hell with you. We never want to see you in civilized society again. And many of the crimes that people are spending time in prison for are relatively low-level crimes, but the laws still dictate very high sentences. The second thing is that somewhere between 5 and 10% of those people are actually innocent. They are pleading guilty because the penalties are so harsh that they feel they have no choice. They're making, in effect, a Hobson's choice between two evils. And they'll take the 10 years in jail because if they went to trial and were convicted, they would do 40 years, and they're not so confident that our legal system would acquit them. We know all this because first, the work of the Innocence Project, which has exonerated now something like 365 people who were convicted of the most serious crimes, murder and rape. And 10% of those pled guilty to crimes that DNA evidence has now established they never committed, and they've been released, but often after 20 or 30 years in prison. But there's a larger study done by what's called the National Registry of Exonerations, which has looked at all the exonerations that have been issued by courts since 1989. And there are over 2,000 of those. And there again, the percentage of people who were shown to be actually innocent, who nevertheless pled guilty to crimes that they never committed, was 8, 9, or 10%, depending how you look at the data. So even if we take a very conservative point of view and say, well, it's only 5%, although I think it's higher. And even if we exclude of the 2.2 million in jails or prison, those who are in jail awaiting judgment, although most of those will plead guilty too. So it's, if we just take 5% of 1.7 million, that very conservative view is still 85,000 human beings who are serving serious prison time for crimes, not only that they never committed, but crimes that the system in effect forced them to plead guilty to.
So related to that, you mentioned the inability of the system, or the skepticism of those who interact with the system, to get it right. You have someone who is pleading guilty in part because of the extraordinary potential sentences, but also because of the reality that rolling the dice and facing much harsher punishment is a tough thing to do when you're not totally confident that the system is going to get it right. In a couple chapters, you walk through in some detail ways in which parts of the system that we assumed were the most reliable are perhaps the least reliable. For example, scientific evidence in the courts, civil and criminal, but particularly in criminal cases, eyewitness testimony, and on and on. And in framing that, in sort of framing a question for you, I thought to myself, well, you know, what do we do? Because as lawyers, we're trained that the adversary system is the way that you get to the truth. The truth will out. You sort of give both sides the ability to go into a neutral forum and argue their case, and you know it sort of works. That's the way it's supposed to work. When you think about the difficulty, though, with scientific evidence, other kinds of evidence that we routinely thought was solid evidence in court, is the answer maybe adversarial legalism is the wrong way to go about it? We need some kind of inquisitorial system, some kind of expert system to figure out the truth, not rely on court cases and lawyers to get to the truth. That was a long question, but the ultimate question, I think.
I'm glad I'm not in your court. Those are difficult questions to answer. Well, let me take it one step at a time. The forensic science, the kind of thing you see on CSI and similar in the movies and the media, fingerprinting, bite marks, hair analysis, and so forth, has been the subject of very serious study by the National Academy of Science. And they have shown that it's highly subjective, that it has, in many cases, a very high error rate. And for example, the FBI itself did a study after much criticism of its microscopic hair matching analysis, and found that in 95% of the 3,000 cases in which its experts had testified about microscopic hair matches, they were either wrong or exaggerated. 95%, that's a huge percentage. A different study, which was done of bite mark comparisons, found that at an absolute minimum, it had a 30% error rate. And the studies, again, from the Innocence Project and from National Academy and National Registry of Exonerations, shows that forensic science is present in something like a third to 40% of all the cases where someone was wrongfully convicted. Going to the solution on that aspect, the National Academy of Science proposed that there be set up a National Institute of Forensic Science, staffed by hard scientists who would determine what was good forensic science, what was not so good forensic science. For example, DNA is good forensic science, and would make recommendations how as to which forensic sciences that were not so good could either be bettered or abandoned, depending how solid they were. I still think that's the best solution. It's strange to me that has never really taken off. Some of the local police labs think it's an affront to what they're doing, but that's not really fair, I think. Turning to eyewitness identification, that's a much harder problem. And that is present according to the Innocence Project, in over 70% of false convictions. By the way, if you're good at arithmetic and you say, well, 40% for forensic science and 70%, that's 110%. That's because in some of these cases of false conviction, there were both kinds of evidence, right? And the problem there is that evidence is so compelling. here's someone, usually a stranger who has no motive to lie, who says, "I'll never forget that face. I saw from my window him assaulting that guy or raping."
And he's sitting right there.
Exactly right, right.
Yeah.
And yet, very frequently, they're wrong. And the reasons they're wrong have to do often with frailties in the human system of perception and memory. So, just to give you a couple of examples, there's the racial factor. People of one race, whether black, white, yellow, or whatever, are much better at perceiving fine facial features of people of their own race than people of another race. So they express equal confidence, and yet, in fact, they're often not nearly as good when the crime that they observe was committed by someone of a different race. A different kind of factor is the tendency of the human memory to merge things together. So you may observe for like 30 seconds someone committing a horrendous crime, and you may have only seen his face very briefly. But a few hours later, you're shown a photo array, which usually is the way it goes now. They've replaced lineups. The photo arrays are much easier to produce, of 7 photos, and asked by the police person, do any of these seem to you to be the person? And you study them because you're conscientious. You study them very carefully. And you finally say, well, I'm not sure, but I think number 3 is maybe the guy. Now, number 3, the photo shows that he has a big scar above his right eyebrow. By the time you go to court, those memories will have unconsciously merged. So you will get on the stand and you will say honestly, but incorrectly, that I'll never forget that face because he had that distinctive scar above his right eyebrow. But what you're really remembering is from the photo array, not from the actual time you saw the culprit. These are things that cannot easily be fixed. While I think it's an interesting discussion and well worth pursuing whether the European system of more judicial hands-on approach to these kinds of issues is preferable. The fact is, judges are often just as ignorant of the frailties of eyewitness testimony as jurors. So I'm afraid the solution there, unlike the National Academy of Science proposal for other forensic science, for eyewitness testimony, I think the only good solution is the inevitable fallback of someone who has no better solution, which is you got to educate people, both jurors and judges, as to the frailties of eyewitness testimony. So they will be much more careful in assessing this. Now, I do think judges have not done a good job of this. The Supreme Court, long before any of these studies came about, in a case called Manson, after the famous Charles Manson, pointed out that eyewitness testimony can often be the subject of problems. They were more focused on bad measures by the police where they, sort of push someone to identify, what about number 3? Yes, right. But nevertheless, they opened the door, but the judges in the lower courts never went through it. There are very few judges who will conduct a pre-trial analysis and hearing on the adequacy of eyewitness testimony, even though the Supreme Court allows them to do that. And I think it's really because they have not become aware of what has been established. There again, by the way, there was a very serious study by the National Academy of sciences that fully evidence all the problems I've just mentioned.
On the topic of reliability and uncertainty, I want to ask you very briefly about the death penalty. You have a chapter in the book that is one of the most moving and personal chapters, because you talk about the death penalty as a phenomenon in this country. You also talk about having presided over a federal death penalty case as a judge. And you also talk about revealing during that proceeding that your brother was a murder victim. Could you talk a little bit about the development of your own thinking about the death penalty, especially today when Virginia, both houses of the Virginia legislature, I think, have recently voted to abolish the death penalty in that state. The federal government executed quite a number of people on death row after no federal executions for something like 15 years. So this is a topic that has become prominent again, and reading that chapter, I found informative but also troubling.
Well, for a long time, I was not able to even talk about this, but I felt I should in the book. My older brother, who was a brilliant and wonderful guy, was murdered in cold blood in a fight over money when he was in his early 40s. And if you had asked me then what should happen to the murderer, I would have said, execute the man, and the sooner the better. And I think that those of us, including myself, who are now opponents of the death penalty, do have to take account of the natural revulsion that people feel, not only when it's someone, as in my case, close to me, but even when you read about it, gruesome murders, mass murders, things like that. I think it's a very natural reaction to feel that person should be executed. They've forfeited their right to live. The problem, and what changed my mind, is again the Innocence Project, because more than any other group, what the Innocence Project showed was that a large number of people on death row were actually innocent, never committed the murder. This was done through DNA tests, which frequently was not available when they were originally convicted. They were convicted through eyewitness testimony or other things we've discussed.
Bite marks.
Yeah. Right. And, but the DNA not only exonerated them and proved they were factually not guilty, often pointed to who the real culprit was. So in some cases, because there's no statute of limitations of murder, the state was even able to go after the real culprit. It seemed to me, when I had my first death penalty case, a case called Canonis, that no system that calls itself just can tolerate the situation where someone who is actually innocent is put to death. And when you know from the Innocence Project results that a fair number of people will be put to death who actually committed no crime whatsoever, to my mind, that's an argument against the death penalty that I find compelling. And I held the death penalty unconstitutional on that ground. I knew I was likely to be reversed.
I
was reversed. I'm glad I still have a certain reality check. But I think I was right. And I think public opinion slowly but surely is coming around to that view. For sure, the penalty should be life imprisonment or 30 years or something very severe until and unless the person is proven innocent. But let's not forget the real possibility that person may be totally innocent and may yet prove that to everyone's satisfaction, including the satisfaction of the very court that sends them. So let's not throw away those lives. Now, there are other arguments against the death penalty, some religious, some because it has been employed in a racially invidious way. And those are all arguments worth pursuing as well. But to my mind, the most compelling argument is, and the one that changed my mind about the death penalty, was the fact that otherwise innocent people will be executed by the state.
I want to ask you a couple more questions, and in about 10 or so minutes, I'd like to start asking some questions from the audience. So just as a reminder, if you're participating in the webinar, please send your questions through the Q&A function for Judge Rakoff. There's a portion of the book that talks about the difficulty or the lack of interest, perhaps, in pursuing criminal prosecutions of high-ranking corporate executives for corporate crimes, white-collar crimes. And you talk about the fact that as a result of, after the Great Recession, there really were very, very few high-level executives at banks, mortgage companies, and the like who were criminally prosecuted. There were obviously prosecutions for insider trading and the like, which tend to be, frankly, as you say, somewhat more straightforward prosecutions to bring. And you're very critical of the Justice Department. You're very critical of the legal infrastructure that allowed people to apparently walk away when other people in the system are clearly being prosecuted much more aggressively. So let me ask my skeptics question. What crimes were those high-level officials committing? And what evidence of those crimes would prove beyond a reasonable doubt that they committed the crime?
So when I was a federal prosecutor, which I was for 7 years, the policy of the Justice Department was not to go after companies, but to go after individuals, and as at highest level as you could prove beyond a reasonable doubt. And it didn't prove all that difficult. It took time. It was no different, to be frank, than prosecuting a mob case. You start at the low level, you convict someone who then flips because he wants to reduce his sentence through cooperation, and you move up the chain. And it was through that that prosecutors in the 1990s and early 2000s, up to about 2006, convicted the CEO of Enron, convicted the CEO of WorldCom, convicted the Charles Keating, the head of the so-called savings and loan fraud. And all these people were convicted of fraud, of having either themselves lied or, more often, having purposely failed to stop what they knew were lies that were being made by their companies to the unsuspecting and gullible purchasers. And I see no reason why that can still not be pursued. It changed roughly around 2006, 2007, in a way that has persisted ever since, to going after the companies rather than the individuals. Why is this? Because it's much, much easier. Under federal law, if even a low-level employee has committed a crime, it is automatically imputed to the company. It's called respondeat superior. And the result is that you can bring in counsel for the company and say, in effect, we got you because we know that fourth level employee committed a crime of fraud. And that counsel will then inevitably say, oh, it's terrible and we want to cooperate. Let us do an investigation. You have limited resources. We can spend millions of dollars and we'll get back to you in 6 months and tell you the results. And they get back in 6 months and they, not surprisingly, tell you that, well, there was a problem which they've cleaned up and maybe they've even fired some mid-level people, but there was nothing at the higher level people were to be blamed for. And, that's given that they are the outside counsel dependent on the higher level executives for their very jobs, so to speak. That's not a surprising result. The prosecutor then says, great, let's negotiate a plea bargain or a deferred plea bargain or a non-prosecution
a monitor agreement.
Right. Right. All of which have terrible collateral consequences for the innocent shareholders who paid all this money, but they didn't do anything. It was others who committed the crime. And I also think, not to get on my high horse, but I think it's morally wrong. If someone commits a crime, those are the people who should be punished, not some abstract entity, the company, which in effect is just viewing this as a cost of doing business, and buying the freedom of those higher level people who orchestrated those crimes. That strikes me as less than perfect justice.
I should tell you that when my students ask me about what it means to do white collar criminal work at a large firm in Manhattan or DC, I tell them that for the most part, unless you're at a firm that represents individual corporate executives, you're probably going to be representing the corporation. And the corporation always wants to obey the law. And therefore, what you're doing is you are, in effect, a private prosecutor. It is a privatization of the prosecutorial function, which I enjoyed working on when I was at a firm. It's very fascinating. I think it does help to ensure that the companies obey the law, but it does also tend to mean that individuals are not necessarily brought through the criminal justice system the way that might otherwise be the case.
And in many cases, it doesn't really change the company that much. The study here, the definitive study, is by Professor Brandon Garrett at Duke, and he studied every corporate prosecution and deferred prosecution from 1996 to when his book came out, which was 2015 or so. And he found that there was a high rate of recidivism. And I don't think that's unexpected because from a company standpoint, this is just a cost of doing business. Yes, we have to pay that fine, and those fines have gotten higher and higher over the years, although some of them are never really paid. They're forgiven. But it's not nearly as much as what they made from the fraudulent actions. And to give one final example that occurred after my book, but I just mentioned it, Purdue Pharma, the company that helped, according to its own guilty plea, orchestrate the opiate crisis that led to the deaths of tens of thousands of people, just a few months ago entered into a plea bargain that involved no individuals, where the company pled guilty and paid on paper an $8 billion fine. But because the company's in bankruptcy, the government quietly agreed to waive all but 250 million of that fine. So that was just a political stunt and not really addressing the problem.
Before we move to questions, and I see a few really great questions in the Q&A, just a final question to you about access to justice more broadly. We've talked mostly about the criminal justice system. The white collar world is in some ways a bridge between the civil and the criminal. One of the chapters in the book that for many people will seem surprising, as someone who teaches civil procedure, it's not surprising, is near the end, where you point out that for anyone of modest means, actually getting representation is highly unlikely. Getting your day in court. You won't get your day in court. And you lay out a number of reasons, including the ever greater cost of hiring a lawyer, the increased expense, apart from legal fees, of the path of pursuing a lawsuit to conclusion, the decline of unions and other institutions that provide members with free representation, the imposition of mandatory arbitration, judicial hostility to class actions, and the increasing diversion of legal disputes to regulatory agencies. So I wanted you to comment.
So I'm impressed that you read to the end of my book.
Well, you know, it was, I thought there must be a light at the end of the tunnel if I get to the end. So can you comment on this a little bit? Because this is a dilemma for anyone who studies the civil justice system, access to justice. And there aren't a lot of good answers, but you have been a judge for many years. You have seen many civil cases, many uncounseled civil cases. What are your thoughts about how we can best turn around that terrible list?
So it is really remarkable how in the last 20, 30 years, everyday working class Americans have been deprived, in effect, of their opportunity to have their day in court. And the statistics, which are put together by a group that monitors all the state courts and compiles statistics for the state courts from all 50 states, is that overall these days, 2/3 of individuals who are parties to a state lawsuit, either they're plaintiffs or defendants, either way, 2/3 of them do not have a lawyer. And that's an astonishing result. And of course, it hugely impacts how well they do. And the same statistics show that they do much, much better. Those who have lawyers do much, much better than those who don't. I think there's no one solution. One step, though, that I think that would help, particularly on the cost side of things, is developing a corps of legal technicians similar to nurse practitioners in the medical profession. So the medical profession, to its great credit, recognizing that doctors were becoming ever more expensive, developed people who had enough training that they could deal with your everyday problems. And when you go to a doctor these days, you often spend most of your time with a nurse practitioner. The doctor always comes in and says, "How are you feeling?" But and those people are a lot less expensive. Now, in the legal system, it seems to me we could develop something similar, where, say, people might go to law school for just 1 year. I know that's heresy to tell a law professor, but and then go out and get some training on the job, so to speak, and then not in the esoteric, complicated cases that involve big specialized lawyers, M&A work, and so forth, but just the everyday cases that people have, housing court cases, family court cases. These legal technicians could represent the clients. When I was a law student at Harvard Law School, I was in the Legal Aid Society, and there, under a Massachusetts ruling going back to the 19th century, I could actually go into court and represent someone, even though I was only a law student. And was I great? No, but I was a lot better than the person would have been without any lawyer. By the way, if you're familiar with the terrific movie Legally Blonde, that's how the hero Elle finally gets to represent the victim in court.
She cites the relevant court rule, and her pompous law professor has to step aside.
That's right. Although there is another law professor there, the woman law professor, who is really very admirable. But any event, and I should finally say on that subject, my brother is a law professor, so I love law professors. But anyway, that's not a total solution, but I think that would be a good first step.
So we have a number of questions. One question related to punishment, and although the Supreme Court has said this is not punishment, it's part of the criminal justice system. Question asks, what's your view of the utility of sex offender registries?
So I am not in a position to comment on their utility, but I would say that I worry about someone being declared a pariah in effect and treated as a pariah after they get out of prison. For example, there are mandatory minimum, very severe mandatory minimum penalties under the federal system for anyone who happens to watch child pornography. This is because it is so difficult to get the people who are producing the child pornography, who are obviously the real culprits here, that the thought is, well, we'll punish the people who watch it, and that will dry up the market. It hasn't worked. It hasn't dried up the market. But a lot of people who, and I don't mean to suggest I approve of what they did, but a lot of people who are otherwise pretty good citizens wind up going to jail for 5 years mandatory minimum because they have to watch some child porn. They get out and they've got to register. And not in every state, but in many states, and in the federal system as well. And if they fail to register, they go back to prison. So I have questions about how effective that is, even though I understand the human impulse that prompts those laws.
This question about your role and your profile. You have had a higher than average profile as a judge. Do you have thoughts about the consequences of the judge becoming the story? And the follow-on to the question is, should judges be able to joust with the press directly? Or is it unfortunate that judges are so circumscribed in their public communications and are really quite restrained in how they communicate publicly?
Well, I think it's a question of degree, but first, the law set forth in the Code of Conduct for Judges, which, by the way, binds all federal judges except the justices of the Supreme Court, who are
they voluntarily.
Yes, that is true. That is fair enough. Anyway, says that on the one hand, you must never comment on a pending case, not just before you, but before any judge in the world. But on the other hand, you are encouraged to speak out when it doesn't involve a particular case or where it involves a case that's long since closed, where it involves what you perceive to be problems with the due administration of justice. And my feeling is that more judges should embrace that latter role. It's really part of their public duty. I only came to this myself after 14 years of basically remaining silent. So it took a while, as we discussed earlier, for me to come to this view. In terms of jousting with the press, that's a losing proposition for anyone. So I wouldn't recommend ever doing that. And in terms of high profile, the good thing in my case is every night I go home to my wife of 45 years. And if I at all think highly of myself, it soon dissipates after hearing her rebuttal.
So this is a question that's a very provocative question. Do you believe the justice system criminalizes poverty with fines and fees, the bail system? For example, people being jailed because they cannot pay fines and fees, or people who spend time in pretrial detention because they cannot pay bail, which affects their ability to keep a job and the like.
So the short answer is yes. There's a famous quote by a 19th century author, Anatole France, that goes to the effect of the law is wonderful in its majesty and equality. It forbids both the rich and poor from stealing a loaf of bread. And so, as you can see, the law does.
I think you originally said it was sleeping under bridges, I believe.
I'm sorry. The statistics are overwhelming. We talked about the 2+ million people in jail or prison. They are overwhelmingly people of low means, of either at the poverty line or not much above. And they are often people of who are not only desperate, but they are people who've had very sad lives. And in my view, yes, we have to worry about never allowing them to commit crimes that would injure innocent people, but we also have to worry about turning those lives around. And we do very little in that regard.
This is another provocative question. Should every criminal judge be required to spend a week in prison to get a sense of what they are meting out?
Well, that may be a little strong medicine. When I was a criminal defense lawyer, it's extremely interesting. I had been a prosecutor for 7 years. Now I was a criminal defense lawyer, and I voluntarily became part of what was called the CJA panel. So I represented indigents as part of my practice. And fortunately for my partners, I also represented people who could pay. But and when I went to the prison, as I almost always had to do in these cases with these poor people, the very same guards who used to treat me like a hero now treated me like dirt because I was part of the enemy. Also, when you first become a federal judge, you usually get a tour of a federal prison, but it's a sanitized tour. And for example, you need to ask, as I did in my own case, to see where they put people in solitary confinement, because that's not part of the tour. But solitary confinement, people literally go crazy in solitary confinement. It is a terrible, terrible place. But I'm not ready quite to spend the week in prison.
When he was still on the bench, Judge Gleason of the Eastern District of New York, who I think many viewers will know is a very prominent former prosecutor who then became a federal judge sitting in Brooklyn. He taught at NYU for many years, and he would take his students up to the women's prison. I don't remember which one. Maybe it was Danbury, but he would take his students up to the prison as part of his course. I think it was a sentencing course to bring home to the students what it means to send somebody to be incarcerated for a long time.
I do the same with my law clerks, and because we have a federal jail, the MCC right across the street. But I always warn them, be sure to get out before closing time.
Here's a question going back to our discussion of reliability of forensic evidence. With such a large portion of forensic evidence, non-DNA related evidence, as you mentioned earlier, as well as many witness testimonies being unreliable, how do you suggest a prosecution can build a fair and factual case that relies less on these common sources of evidence?
So that's a terrific question. I think I would distinguish the role of the police and the prosecutor. The people who gather the evidence are the police. And yes, in federal cases, the prosecutors will sometimes play an investigative role using the grand jury, but it's still primarily the FBI or the SEC that's doing the legwork. Where prosecutors, I think, could improve their own cases and also the role of truth in the system is to be more skeptical of what is being presented to them. So what they should do, in my view, is ask the questions of the police and the agents that they know a good defense lawyer would ask. Now, the reason they don't usually do that is they've never been a defense lawyer. I have one very wild-eyed proposal in my book, which I don't think will be adopted, but I think should be adopted, which is that every prosecutor be asked to spend 6 months out of every 3 years as a criminal defense lawyer for indigent defendants in another district.
And you make reference to the British system where barristers do that.
Exactly right. So it's not without precedent, and is done in effect in England. I think that would allow them to see that there are hard questions they should ask to make their cases better and to avoid innocent people being punished. And generally, I think would improve the balance of the system. But to be frank, I'm not too optimistic that it's going to be embraced by the powers that be.
So we have 1 minute left. I want to tell you, by the way, I have a law school classmate who has worked as a public defender for many years, and he has told me on a number of occasions that he thinks prosecutors would be better, more effective, but also more even-handed if they had to serve as defense attorneys and swap places, which, by the way, is done in the military. If you've ever worked with military prosecutors and defense attorneys, they play all the roles. That you'll be a defense attorney, then a prosecutor, then you might be a judge, and then go back to being a line attorney, being a defense attorney or prosecutor. So this is a kind of wry comment. I think we'll end here. This is a question asking for your response. When I observed court a couple times, it seemed I could tell the outcome before anyone said a word. The lawyer who had the more expensive suit seemed to be on the winning side all the time. Please comment.
Well, as someone who can barely afford expensive suits on a judge's salary, I understand that question. I think the role of the judge there is important. The the way it's normally perceived is the judge should take no role. And then if one lawyer is really good and the other lawyer is not so good, you are right, that will have a major impact on the outcome. And that's the way the adversary system in some ways is supposed to work. But it's not really what the heart of the adversary system is, which is that each side has a champion and then a neutral person, either a judge or jury, makes the decision. And so I try to balance that a little. It's a question of degree, but I'll give you an example. If I think one lawyer, the less good lawyer, has not asked a critical question of a witness who he's cross-examining, I will call over the lawyers to the sidebar and I will say, gee, I'll bet the jury is wondering what the answer is to question X. I wish someone here would ask that question. And lo and behold, the lawyer that asked that question. Now, you can't do that, more than once or twice in a day max, but I do try to redress it a little bit because of the problem that the questioner has identified.
Well, Judge Rakoff, we've come to the end of our time. This has been fantastic. Again, the book is Why the Innocent Plead Guilty and the Guilty Go Free and Other Paradoxes of Our Broken Legal System by the Honorable Jed S. Rakoff.
It's been a pleasure. Thank you.
And great moderating, Professor McKenzie and Judge. You have done a real service providing such a sobering and enlightening assessment of our very imperfect justice system. Let's hope your book helps bring about the kinds of reforms that you persuasively argue are necessary. To all of you watching, thanks again for tuning in. A reminder that in the chat column, you can find a link to purchase Judge Rakoff's book. From all of us here at Politics and Prose, stay well and well read.